Hi there. Our next speaker for the Hidden Heroes Veterans Caregiver Week is Mr. Kerry Peck from Peck, Ritchey, LLC. He is the managing partner at Peck, Ritchey, and he will be speaking today on legal issues to consider while aging. Again, if you have any questions, please put them in the comments or the chat section, and we will answer those right after this presentation. Please welcome Mr. Kerry Peck.
Good afternoon, ladies and gentlemen. My name is Kerry Peck. I lead the law firm of Peck Ritchey. We focus our practice on issues relating to aging, disability, death, dying, and taxes, with offices in Chicago, Northbrook, and Oakbrook. I'm pleased to be here today and thank ElderWorks for the kind invitation. Today we're going to talk about legal issues to consider while aging, and let's get going. So today we're going to talk about kind of basic issues. What is estate planning? What is probate? And what are powers of attorney for both healthcare and property? In Illinois, we have two kinds of powers of attorney, and in fact, they are one for property and one for healthcare. Next slide. So what is estate planning? Estate planning focuses in general, most people think estate planning focuses on post-death distribution of assets, when in fact, estate planning is important to focus on lifetime estate planning so that we have advanced planning for the management of your financial affairs should you become incapable. And likewise, advanced planning for your healthcare decision-making should you become incapable. Two very, very important aspects of estate planning. In addition, when we do estate planning, we'd like to, if we can, avoid probate. There's two types of probates here in Illinois. One is a lifetime probate, which is a guardianship. Does an individual require a third party to make decisions for them? If so, who should it be? And the second type of probate most people focus on is a post-death probate, in which assets run through the probate, debts are paid, and ultimately the assets are distributed appropriately under the terms of an estate plan or under the terms of the Illinois descent and distribution laws, which apply if someone dies without a will. In addition, in estate planning, we have the ability to do estate tax planning. In Illinois, assets above $4 million are taxed by an Illinois inheritance tax. On the federal side, assets above roughly $11 million and some change are taxed by the United States government. And finally, estate planning allows us to do some asset protection planning. Under certain circumstances, we can create trusts that are protected from the claims of creditors. So who needs estate planning? And really the answer is very simplistic. Everyone needs estate planning. Why? Because if you don't have a will, the state of Illinois and all 50 states in our country have already written a will for you. And again, that's what's called the laws of descent and distribution. The fancy term is one dies intestate if they die without a will. So if you die without a will, and hypothetically, I die without a will, I'm married with 2 children. My children are ages 5 and 7. My wife gets half of my assets, and my children get the other half of my assets, regardless of age or regardless of need. Now, clearly, that's not the intent of most married couples. Most married couples want their assets to go to their surviving spouse, who will take care of their minor children. So in addition, estate planning, of course, as I mentioned a moment ago on the prior slide, relates to lifetime planning, power of attorney for healthcare, power of attorney for property. And we'll talk about that a little further into our presentation. So what's our goal in estate planning? Well, we want to provide peace of mind for both you and your loved ones while you're healthy, when you need help, and after your passing. So even before estate taxes, the goal of estate planning was to protect assets from creditors, to preserve family wealth for future generations, to provide for support and income flow to families under all circumstances, to manage assets for those who cannot manage themselves, and business succession planning. So what can I expect when I do estate planning? You will be asked how and who will manage your assets should you become disabled during your lifetime. You will be asked the same question as it relates to your personal care and your health care. Should you become disabled or incapacitated during life, who's going to manage your affairs and what instructions are you giving them? For example, relative to end-of-life treatment. In addition, under what circumstances does it make sense to distribute your assets during your lifetime? How are your assets and to whom are they going to be distributed post-death? Who will be the guardian, the decision maker, if you have any minor children, should you become disabled and or die? If there's a simultaneous death accident with you and your spouse, who's going to manage the affairs and the assets of your minor children that you leave them? In addition, we're going to talk about, in the context of when we do estate planning, various ways of preserving the estate assets for your beneficiary's benefit. And of course, tax planning. Are there any strategies we can employ to reduce or postpone paying estate tax? Often the estate taxes are not due until the passing of the second spouse in a married couple. So what's probate? Well, I mentioned there's two types of probates. This probate is a post-death probate. The other is a lifetime probate, a guardianship. Does Kerry need a guardian? If so, who should it be? Who's going to manage his affairs? But on the slide that's currently on the screen, we're talking about a post-death probate. And there's a lot of mythology in conjunction with post-death probates. Assets in my name alone that do not have a named beneficiary, if they exceed $100,000 in value, are required to go through a post-death probate. That probate is an artificial tax-paying entity opened in the probate court in the county in which an individual dies and resides. Cook County has on the entire 18th floor of the Daly Center for both post-death probate and lifetime probate. The law requires in Illinois that post-death probates must be open not less than 6 months. Typically, they're open 9 months to perhaps 2 years, depending on if there's any litigation between the beneficiaries over the assets. Typical costs include attorney's fees, executor's fees, court fees, clerk's fees, and of course, a probate gives someone a venue, a forum, to file a will contest seeking to overturn that will. Probate is a public proceeding, okay? A revocable living trust can be used in an estate plan to avoid that public proceeding. Next slide, please. So here's an example of the king of rock and roll, Elvis. He died with a gross estate of about $10 million. But Elvis didn't do any planning. Elvis never thought, like many of us, that he was going to die. And about 73% of Elvis's assets were lost in the probate process to either estate taxes or other settlement costs. He had debts of almost $4 million. He had administrative, legal, and executor's fees of almost $2 million, estate taxes of over $3 million, and he left to his heirs, Priscilla, less than $1 million, starting with a gross of 10.1. a rather stunning example of a bad situation that easily could have been rectified with planning. So how do we avoid that post-death probate? We own assets in joint tenancy. So husband and wife own an asset in joint tenancy. They own the house. Husband dies. Wife gets the house, even if it's subject to a mortgage, and it avoids probate. Joint tenancies. Joint tenancy can be applied to bank accounts, brokerage accounts, automobiles, almost, but not everything, almost everything. Life insurance. If I have a life insurance policy on my life and my beneficiary is my wife or one of my children or multiple beneficiaries, upon my passing, that life insurance policy and the proceeds go to the beneficiaries. It avoids probate. We do not need to open a probate case in the circuit court. Another common method of avoiding probate is payable on death accounts, or POD. POD is short for payable on death. If I own an account and it's payable on death to my daughter, upon my demise, my daughter will advise the bank that I have passed, and that asset and the proceeds will pass to her, avoiding probate. Lifetime gifts, of course. You can gift up to $15,000 to as many people as you like and not pay tax and reduce the value of your taxable estate. Likewise, a living trust, commonly referred to as a revocable living trust, is probably the most common state-of-the-art method of avoiding probate. Revocable living trust is a device we create. I name myself trustee, so I retain control of my assets, and under the terms of the trust, the assets that are funded in to the probate pass upon my demise. Use of a revocable living trust is a private process. It can be done in my law firm conference room. We need not open a probate estate to do so. So as I mentioned, avoiding probate, joint tenancy. Joint tenancy is short for right of survivorship. Now, it's a great way to avoid probate, but sometimes it causes other problems. If I put my house in joint tenancy with my daughter, and my daughter gets divorced, her estranged spouse is likely to seek to draw that house into the divorce and determine whether he has any interest in that house. Joint tenancy clearly is used often to postpone probate until the second spouse, the surviving spouse, dies. If we create a joint tenancy, husband and wife, or husband and daughter and son, it's difficult to remove them from co-ownership as a joint tenant. In addition, in my example, myself, my son, my daughter, if one of them gets in an automobile accident and they do not have adequate insurance for the injuries caused to the other driver in a hypothetical auto accident, it may expose my assets to that personal injury case. And likewise, probate, the use of joint tenancy to avoid probate may unintentionally disinherit heirs. Again, A and B own a house together, or more commonly, what we see is dad dies, mom is left behind, and she puts one of her daughters on her joint tenancy account to help her write checks and pay bills. When she dies, that money goes to that daughter, and it may unintentionally disinherit her other children. We've already talked about the use of trusts, a revocable living trust, to avoid probate. Next slide, please. So a last will and testament is a document that has no validity during lifetime. We frequently get calls from people who say, I'm named executor of my uncle's estate or my aunt's estate, They won't do what we want. Well, you have no power whatsoever as a nominated executor under a last will and testament until that individual is deceased and until that that will is admitted to probate. So a last will and testament is becomes operational only on death. The executor that's appointed will be the person entrusted with managing your assets after you're gone and distributing those assets, paying your debts under the terms of the will. It is a public document, as I mentioned. Last will and testament. The law in Illinois requires that we file the last will and testament with the clerk of the circuit court within 30 days of the death of an individual. And as mentioned earlier, a will does not avoid probate. Next slide, please. So a revocable living trust, as I mentioned, does avoid probate. It really takes the place of the will, but we still have a will with a revocable living trust. Why? Because we use what's commonly referred to as a pour over will. Any assets that are not funded into the trust, pour over into the trust. So fundamentally, what we do with a revocable living trust is we change the title of our assets and put it into the trust. The assets are assigned to the trust to avoid probate. Again, this is the state-of-the-art mechanism for avoiding a probate case. The document is private, and because it's revocable, it's amendable at any time. It avoids the need for a guardianship. That's that lifetime probate. A guardianship is avoided because I name someone to manage my trust and my assets as my successor trustee when I'm not capable of managing my own affairs. It also allows for estate tax planning in my revocable living trust. Significantly, there is no asset protection for the person creating the trust maker. It does provide a mechanism for to manage the assets for beneficiaries and can provide them creditor protection. And it's an integral part of an estate plan. Today, typically, there are 4 documents created in an estate plan: a power of attorney for healthcare, power of attorney for property, revocable living trust, and a will. So if someone asks you to use an irrevocable trust, your antennas should go up. You should think long and hard and find out why. Irrevocable versus revocable. Irrevocable means what it says. You can't change it. It is used to facilitate gifts and sometimes Medicaid planning, but it's critically important you understand why you would be signing an irrevocable trust. You cannot make changes to an irrevocable trust, and many complex tax strategies incorporate some use of an irrevocable trust. Next slide, please. So, powers of attorney. In Illinois, we have 2 flavors, okay? The first is a power of attorney for property. And let's use the full name, a durable power of attorney for property. What is that? Durability language. That means when I'm cognitively impaired, the document I've signed while I was competent continues to be valid. So I sign a durable power of attorney for property to manage my assets. It's a generic term. It's not just real estate. It's a generic term for all of your assets. That durability portion, as I mentioned, allows the power of attorney for property and the power of attorney for health care to remain valid when I'm not competent. What do? I name an agent, someone else, to make decisions for me when I'm not capable of making decisions on my own. I must be competent at the time that those documents are signed. I must understand what I'm doing. I must carefully choose my agent. I am choosing an agent. I am known as the principal, not of the school. I'm creating a principal agency relationship. So I'm the principal. I name my wife, my daughter, my son as my agent to make decisions for me in the areas of asset management and healthcare, should I not be able to make my own decisions. Next slide, please. So these are the Doublemint twins. And in a power of attorney, we create authority and give authority to someone else to act for you in the certain circumstances as your legal clone. Your legal clone. Again, a principal agency relationship. Next, there we go. So in our power of attorney for property, as I mentioned, both of these, power of attorney for property, power of attorney for healthcare, we appoint an agent to make decisions when we're incapacitated. It avoids guardianship because I've named someone. This is a lifetime document. These documents, powers of attorney for healthcare, power of attorney for property, are lifetime documents. They die when you die. And so the agent you've named to make your healthcare and financial decisions when you're incapacitated allows you to avoid going into guardianship court should you become incapacitated. And without a power of attorney for healthcare and without a power of attorney for property, that's where you would end up. So our power of attorney for property includes the authority to manage real estate. It includes the authority to manage healthcare savings accounts, IRAs, retirement plans, property that wasn't put in a trust. It allows us to get HIPAA-protected language if we're the agent under power of attorney for healthcare. It allows our doctors to consult with our agent regarding options for surgery, for medical treatment. It allows our agent under healthcare power of attorney to get access to all of the medical records. You can't even go into a doctor's office today without being told that's HIPAA protected. And certainly in the hospital, it's HIPAA protected, HIPPA, confidential, protected by the law, by a federal law. An agent under a power of attorney that goes in and says, here's my power of attorney, gets access to HIPAA protected information. So what happens if our advance directives or our power of attorney for healthcare, our power of attorney for property are not in place or they fail? Then we go our lifetime probate route. Remember I told you there were two, a lifetime and a post-death. Primary purpose of our lifetime guardianship probate case is to establish a legally authorized substitute decision maker for someone who lacks capacity to make or communicate responsible decisions. Guardianship should only be used when it's necessary to promote the well-being of a now disabled person, protect him or her from neglect, exploitation, and to encourage development of that individual's maximum self-reliance and independence. So we say in the probate court to simply establish certain disabilities is alone insufficient to support the determination of incompetency. Evidence must show the person's inability or incapacity of managing their person, which is medical decision-making, and their estate, which is financial decision-making. So lifetime probate, we can avoid it. Post-death probate, we can avoid it. We need to plan. We need to consult an attorney who understands this area of the law and plan in advance. So guardians come in two forms. A guardian of the person makes medical decisions, makes residential placement decisions subject to court approval. A guardian cannot force someone into a facility against their will. A guardian of the person, there's a guardian of the person for medical and a guardian of the estate for asset management. Guardian of the person ensures that the disabled person receives proper medical care. Guardian of the person has access to that HIPAA protected language. And as I mentioned, we have limited powers with regard to mental health decisions or placing someone. We cannot admit someone against their will to a mental health facility. That's an entirely different procedure, and that's commonly referred to as an involuntary civil commitment. If someone requires psychiatric treatment against their will, then it's required to file an involuntary civil commitment case. Next slide, please. So our guardian of the estate is going to make financial decisions, enter into contracts, take action to benefit the estate for tax purposes, sometimes do estate planning subject to court approval, file a lawsuit, perhaps to collect money or protect your property. That guardian of the estate can sell real estate subject to court approval. And that guardian of the estate can apply for government benefits, VA benefits, Social Security disability, as well as that guardian has a fiduciary duty to investigate and pursue eligibility for government benefits that may enhance the life of the older adult that's the subject of that guardianship. So when we file for guardianship in Illinois and in Cook County, although all the counties surrounding Cook County, the collar counties, have created a similar form. In Cook County, we use a medical form called the CCP 211. That must be completed by a physician that's examined the subject person of the guardianship within 90 days. We don't want any stale or old medical information. And the doctor is required to determine whether or not an individual suffers from partial incapacity or total incapacity to make their personal and or financial decisions. The form requires the doctor lay out basically a diagnosis, a prognosis, comment on their mental deterioration or capacity, physical incapacity. Do they suffer from a mental illness, for example, bipolar disease? Do they suffer from a developmental disability? What would be the appropriate living situation for them? And are they capable of managing their ADLs, all aspects of daily living, bathing, dressing, hygiene, clothes, toileting, eating, preparing meals, things of that nature? This is important, critical information to a judge as he or she determines whether someone requires a court-appointed guardian. So how do we do this when we file for temporary guardianship? It's an emergency procedure. We typically file for emergency temporary guardianship when someone is being financially exploited or someone requires urgent surgery. And the judge must have a medical report prepared by an MD, not a PhD. No other medical personnel will do the trick. Has to be an MD. We file that emergency temporary guardianship simultaneously with what's called the plenary, PLENARY, guardianship. That's a full guardian. Law requires we file for both. And we need to tell the court why we are filing for temporary guardianship. We need to focus on the immediate welfare and protection of that individual who may be financially exploited or that individual who requires emergency surgery. What is the emergency, Judge? Does it relate to medical? Does it relate to money management, asset protection? tell the court what the emergency is. Now, when these documents are filed, the court will appoint a guardian ad litem. Typically, the acronym is GAL. That GAL will go out and act as the eyes and ears of the court. That GAL will go out. It's usually court-appointed guardian ad litem as a lawyer. They will go out to the nursing home, to a hospital, to the individual's apartment, condominium, because the judge can't go out and see all the people that have cases pending in front of him or her. So the judge appoints a lawyer to go out and do this for them and advise them, that individual, of their probate rights. I call them the probate Miranda rights. You have the right to consent. You have the right to oppose. You have the right to appear in court. You have the right to a court-appointed lawyer. You even have the right to a jury trial, which is very, very rarely used. In addition, that guardian ad litem, the eyes and ears of the court, will give a mini mental status exam to the alleged disabled person. That's the person that's subject of the guardianship, and report back to the court on his or her findings in conjunction with the assessment of this individual's ability to make decisions and communicate responsible decisions. So here's some examples of poor estate planning, and they all come out of the beautiful hills in Hollywood, well-known actors and actresses, and, of course, rock and roll. Jim Morrison. Jim Morrison died of heart failure at the age of 27, a little hard to believe, way back in 1971. He had a very simplistic two-page will. His entire estate was left to his girlfriend, or if she had passed, to his brothers and sisters. Well, Jim Morrison's girlfriend died without a will. So Jim's estate and his interest in the Doors transferred to the girlfriend's parents. Jim's parents disputed the estate going to the girlfriend's parents, of course, and her parents ultimately agreed to provide Jim's parents with half of the inherited estate. A horrific example of bad planning. Prince, Purple Rain favorite, Little Red Corvette. Singer, songwriter, musician. He died in 2016 from an accidental overdose of drugs, the age of 57, without a will. Many people claimed that they were his heirs, and the court determined that he had 6 sibling heirs. One heir died, opening his estate to the parties not related to him as a result of that heir's will. This is an example of no planning. Again, die without a will, the government has it written for you. It may not be the one you want. I don't know if Prince wanted his assets split among his 6 heirs, or his brothers and sisters, or he favored one over more, or he wanted to make charitable contributions, on and on. We don't know what he wanted. He didn't put it in print. He died without a will. You don't have to be a rock and roll star to learn from this instance. Dying without a will is not the way you want to go. Sonny Bono, he died in a skiing accident. Left behind his wife, his 3 children, and approximately $2 million in 1998. His wife, Mary, had to petition the court to be appointed executor. Sonny had no estate planning. Now, Cher filed a lawsuit against his estate for approximately $1.6 million that he never paid her under their 1975 divorce. Another man claimed to be Sonny's love child, and he ultimately did not prevail because he couldn't produce DNA. But disputes between heirs, potential heirs, love children, his first wife, Cher, complicated and prolonged the settling of his estate. Again, no planning whatsoever. James Gandolfini, The Sopranos, the boss in The Sopranos, dies at the ripe old age of 51 with an estate worth approximately $70 million. He left his will left about 80% of his estate exposed to taxes. His estate was depleted by about $30 million in taxes. A stunning example of poor planning. Tax planning is critical to people who have assets that ultimately are going to be taxed and taken away from the family. Robin Williams. Robin Williams, famous for Mindy and More and Mrs. Doubtfire, as well as Popeye. Poor Robin Williams had a long history of mental health problems. In 2014, he committed suicide. He had been misdiagnosed with Parkinson's. However, it was spreading to some degree. His suicide may have been a result of his struggles with depression, including perhaps that misdiagnosis. He left behind an estate estimated over $100 million. He was married 3 times. He had 3 children. They were all named as heirs. His final wife disputed how much money she needed to remain in the home with Robin's belongings, many of them acquired prior to their marriage. And she acted against his will by challenging his plan in public. Again, yet another example of a high-profile star doing very, very poor planning. So at the end of the day, plan now. Don't delay your estate planning. We hope everybody lives a long, prosperous life, but none of us have that crystal ball that can determine the future. Don't allow your hard-earned family wealth to be wasted. Estate planning is critical to preserving your family wealth and maybe your family emotional health. It's important to begin the process now. Thank you for coming out, ladies and gentlemen. If we can help you, please let us know. We offer our potential clients an initial consultation for 30 minutes by phone, by Zoom, in person at our Chicago, Northbrook, or Oakbrook office. And if we can help you, please let us know. Thank you very much for coming out today, and have a wonderful day.
Wonderful. Thank you, Kerry. That was fabulous.
Thank you, Jennifer.
You're welcome. It's, I've listened to you many, many times, and it never gets old. I love your message. Plan, plan, plan again, right? That's your message.
All true. Very, very important. We've got a classic examples of people that have access to the best lawyers in the country, maybe the world, with millions and millions of dollars. And you can see that having a lot of money doesn't help people make this important decision. So
No,
this is the decision that will help your family, both economically and perhaps maintain family dynamics at a calm and stable basis.
One can only hope. So what is your advice for a person who has, normal income, normal assets? When should they consider putting together a trust? At what dollar amount? Or should they consider one for just the house? Or what are your recommendations on that?
Well, I think in general, we need to know specifically what people have, who they want to leave it to, because sometimes, we assume people want to leave their assets to their spouse. If it's a second marriage, we're seeing an awful lot of scenarios in which people don't want to leave their assets to their second spouse. They want to leave it to their children from the first marriage. So those are increasingly common. And as you say, average, income, average assets. It really depends on the situation, which is why we encourage people, contact us. We're happy to talk to you at no cost, no obligation. Find out if you like us, find out if we can help you, if there's chemistry, so to speak, between, the law firm and you. And then we'll let you know what it costs, and we'll put it in writing, and we'll be completely transparent because everybody's situation is slightly different. Clearly, there are some commonalities that run through, people's planning. Everybody, for example, needs a power of attorney for healthcare and a power of attorney for property. Should they become unable to make decisions for themselves, they should have in place someone that can make decisions for them. And the reality is we never know when we're not going to be able to make our own decisions. I was in a car accident about 2 weeks ago, and it's just the whole thing is stunning. You just don't know what tomorrow is going to bring.
I did not know that. That's a good point. You don't know what's going to happen within an hour. You just
Right.
have to do what you can do to protect you and your family.
Right.
What about the LGBTQ plus population? And then this conversation we're having is nationwide, so it's not just for Illinois.
Right.
Some states don't recognize the same-sex marriages and such. So what is your recommendation in that case?
Well, if the state doesn't recognize same-sex marriage, they may or may not have a civil process that allows you to be a partner under civil law that's not a marriage. And you specifically, there's no question LGBTQ community has specific issues. We're equipped to do that. And I think that you need to look for a lawyer that's had some experience, regardless of where you live, that's had some experience in that world. When you pick a lawyer to do your estate planning, much like you don't go to a podiatrist for a heart problem, you want to pick a lawyer that has some experience in dealing with these issues, the whole gamut of these issues, regardless of how much money you have or you think you don't have much money. Again, you may have a stepchild, you may have an adopted child, you may have a complete different variation. As you suggest, Jennifer, you may live in a state in which you want to have a marriage and you can't do it. And so these are all issues. I encourage you to choose your lawyers wisely. Find out what your lawyer's been involved in the community. Is your lawyer giving lectures? Is your lawyer affiliated with an academic institution? Is your lawyer a member of the National Academy of Elder Law Attorneys? What is your potential lawyer done to demonstrate to you and the community that they have experience in the area that you're hiring him or her to provide professional legal services?
Yeah, and I think that's very important. You hit it on the head. You have to get along with the attorney. I know that's some of the advice we offer at ElderWorks is make sure you like them, because you're going to be working with them a long time, hopefully, knock on wood.
Yeah.
And same thing with the realtor. Make sure you like them.
Yeah, I mean, it's a close relationship, and you need to like this person, and you need to, I was president of the 22,000 Lawyers Chicago Bar Association. I've written 2 books at the request of the American Bar on Alzheimer's disease. So pick someone that you have confidence in, and you like them, and you know that their staff is responsive. That's really, important in a attorney-client relationship.
100%. 100%. And you have to make sure that they are qualified to help you with the situation that you're currently in.
Right.
I know that I've had some clients whose parents have used an attorney forever, but that attorney is not an estate planner. They're not an elder law attorney. They're a generalist. So how good are they at planning for that person's future? You don't really know. They might be a generalist, and I would prefer a specialist.
Yeah, I agree.
Yeah, I know you do.
The analogy it goes directly back to medicine. If you have a bone fracture, you want to go to an orthopedic surgeon. You're not going to go again to a podiatrist for a specific problem that requires a specialization.
100%. I don't see any other questions, so let me see here. I did write down some notes. You were mentioning probate and avoiding probate, planning for that. What happens if, I know you were talking about guardianship a bit. what happens if mom and dad were fine and now mom and dad are not fine? Someone passes away, the other one was overcompensating, the other one has memory loss, and a guardian has to be put in place. What is that process? How does someone work through that process?
Well, guardianship is really what I call a lifetime probate. And a guardianship case is a court determination that someone needs a third party decision maker. It could be a child, it could be a relative, it could be a not for profit guardianship agency. But the reality is, question posed in this kind of court proceeding is, does mom or dad or the person that's the subject of the guardianship have the mental capacity to make decisions for themselves? And those decisions fall in two categories. One is healthcare, and one is the management of assets. And so that decision is ultimately based on medical evidence. When we file such a guardianship case, we go in with a medical report that says Jane Doe doesn't have the capacity, Your Honor, to manage her affairs. And specifically, she doesn't have the ability to manage her financial affairs, and she doesn't have the ability to manage her health decision making. So these are very, very important proceedings. They are significant proceedings. They are a civil proceeding, which is that results in a deprivation of civil liberties. If you're adjudicated disabled, you lose the right to vote. You lose the right to drive. You lose the right to hire somebody to work on your house or to paint your car, things of that nature. So this is a really important process. The court in general affords significant due process to that person, appoints a lawyer, a guardian ad litem, to go out and visit with that individual, advise them of their rights, and report back to the court on his or her findings regarding both capacity and whether that individual says, you know what, it's okay if Jennifer's my guardian, or I don't want Jennifer to be my guardian. I might settle for somebody else. So this is a very important interaction. The court-appointed guardian ad litem acts as the eyes and ears of the court. Goes out to a nursing home, goes out to the condo, goes out to the hospital, reviews the medical records, and reports back to the court on his or her finding. So that's an important component in a guardianship, and that individual plays a significant role in making recommendations to the judge, both as to the qualifications of the proposed guardian, meaning perhaps you, Jennifer, and the agreement or disagreement of the alleged disabled person, the person that requires a guardian. So again, this is an area, a very specialized area of the law. Choose your lawyers wisely. Make sure they understand the local process. Make sure they've done it, many, many, many times before, and can, get you in and out through this process. It is not a seamless process, but there will be some bumps and bruises along the way. Nevertheless, an experienced attorney in this arena will know how to do that.
Excellent. And if a adult child or friend or neighbor notices someone's not being taken care of appropriately or being financially exploited, what kind of recourse do they have if it's an adult child who's doing it, or even a guardian? What do they do? Do they call you? Do they call the police? Who do they call first?
I think that the answer is they probably call, shall we say, all of the above. Depending on the circumstances, you may decide you want to pick up the phone and dial 911. Each police department responds differently to these problems. You may want to call an attorney who's familiar with financial exploitation cases. I was engaged by the city of Chicago to rewrite the state of Illinois Elder Abuse and Neglect Act. So we've written financial exploitation statutes to prevent financial exploitation at the city, state, and federal level, and been involved in that. Also, we have throughout the country an adult protective services program. You can contact them generally through your local senior center. They will send a social worker out to investigate the alleged exploitation. But, exploitation comes in a lot of forms today. It comes with quote unquote loving families stealing money, often putting it up their nose, in their arm, spending it at the casinos. It comes in the format of caregivers stealing money, getting access to bank records. You're going to put a caregiver in your mother's home or your father's home or their condominium. Take all of the financial records out. All of the financial records out. Take the jewelry out, et cetera, et cetera. Everything of value, get out of the house. We just see caregivers, there are very good caregivers and there are very bad caregivers. And caregivers often have access to personal information and sometimes use it to enrich themselves. So if you have a financial exploitation case, or you're concerned, there are a variety of places to go, and I would encourage you to get active. Don't look the other way and think it's going to go away. It's going to get worse. Don't forget, financial exploitation also comes these days on the telephone. Older adults are getting what's commonly referred to as the grandparents scam, middle of the night. Hey, Grandma, it's Johnny. I'm in jail. I need $5,000. Please wire it to me as quickly so I can get out of jail. Well, a lot of grandmas and grandpas do that because they want to protect their grandchildren. And more often than not, it's a scam. A lot of scams these days come on the internet, okay? If you're computer savvy, don't give your personal information out on the internet. We're seeing a lot of scams on the internet, what's commonly today referred to as romance scams. Lonely older adults of both sexes meet somebody on the internet and they're persuaded to send them money, large sums of money for quote unquote love on the internet. So these are big problems. Nora O'Donnell covered this the other day on the national news. We're seeing it in droves. It is an epidemic. Financial exploitation of older adults is an epidemic. Watch out. Don't trust people that are new to your life, no matter how sweet or loving they appear to be.
I agree with you 100%. And don't answer the phone. If you don't recognize the number, don't answer the phone. Let them leave a message and a phone number to call back and verify that phone number is really them, because people can change their ID to anything at all. I also have a friend actually whose father was in love with a person from the Philippines. He went there, he met her, they were going to get married. She passed away. And he was basically supporting her family. He was sending money there all the time. Well, then she passed away, and then her best friend continued to solicit him, and now he's funding them again. What do you do when someone's got their full cognition? Is there anything you can do whatsoever?
There isn't much you can do. I was involved in a guardianship case in which the woman the doctor indicated that the woman had one blind spot. She was a community leader, one blind spot, and that was, her love interest and romance in the person on the internet. So it's a real problem. I mean, it's a real problem. We just have a lot of lonely people that believe that,
yes.
I was involved I've been involved in cases where 6 figures in money have been sent to people that the older adult has never met. Honey, I'm coming to visit. Honey, I'm going to marry you. Honey, we're going to buy a house. Just send me money so I can buy the plane tickets. Just send me money so I can get the marriage license. Just send me money. And that's what it's all about. Just send me money. And
so the key is if they're asking for money, right? I said the key is if they're asking for money, right. That's kind of the red flag, isn't it?
Yeah. If they're asking for money, no matter what the cause is, you should just say no. And the truth is, if you're lonely and you want to meet somebody, please go to the local senior center or go to church or synagogue or the local community college. Don't send money to someone who you see, like I'm looking at Jennifer on a Zoom call, because they ask for money and they promise you the sun, the moon, and the stars, and they promise you they'll be your love romantic partner the rest of your days. Ladies and gentlemen, it's a scam, and it is such a big scam. We're finding the government is having very, very limited success tracing this money. In many instances, it's going offshore. It's going to places that can't be traced, and you're not getting the money back. You're not getting the money back, and you're going to need that money for your own use and your own health care. So please use good judgment and don't send money to somebody that you meet on the internet.
Absolutely. Thank you so much, Kerry, for being on today. And if anyone needs some help with their estate planning, or they have concerns with abuse of any kind, Kerry Peck and his team at Peck Ritchey are fabulous. ElderWorks refers to them all the time. We're very careful who we refer to, so it is imperative that everybody gets referrals. You need referrals, contact ElderWorks. We do try to vet the folks that we refer to, such as Peck Ritchey. So thank you, Kerry. Appreciate it.
Thank you for having me, Jennifer. And since we're on a nationwide program, I'm licensed in Florida. And if we can help you find a lawyer where you live, let me know. We have a national network of lawyers that we refer to. So Jennifer, thank you very much for having me again.
No problem.
And appreciate it. Take care, ladies and gentlemen. Be safe and stay healthy.
Thanks, Kerry. Bye-bye.
Bye-bye now.